and also to provide reasonable accommodation to employees with disabilities.
Still on that beat, civil society groups, legal experts and disability rights advocates are warning that Kenya's justice system remains fundamentally exclusionary, especially for persons with disabilities. At the heart of the concern is the continued use of outdated colonial-era laws like the Criminal Procedure Code of 1962, which activists say discriminate against people with psychosocial and intellectual disabilities. A newly launched report by the International Commission of Jurists Kenya chapter reveals that despite recent legal reforms, including the Persons with Disabilities Act 2025, and the newly unveiled National Disability Policy, many courts still lack mechanisms for inclusion, reasonable accommodation, or even basic assistive devices.
Today, we are launching a report titled Access to Justice for Persons with Disabilities, Progress and Challenges, which captures the extent to which the right to access justice for persons with disabilities has been realized. This is a very opportune moment for various stakeholders, including persons with disabilities, because the Persons with Disabilities Act 2025 was recently enacted in May, and it has a specific provision on access to justice. And just earlier today, we had the government launch the national policy on disability.
So the report also highlights the challenges, the long road that we still have to walk as a country to make the judicial system and access to justice a reality for all people with disabilities. The majority of people with psychosocial disabilities are the ones who are most discriminated when it comes to the judicial process. So we have seen the cases where because of the president can detain you indefinitely, sometimes for a long period of time, even sometimes 10, 15 years. And when you're detained in that manner, it means you're denied, your right to be heard in a court process, and this also violates your rights. So the report shows that we still have to do a lot of reforms.
They deserve to be given an equal platform for participation within our criminal justice processes and also the civil justice system. Unfortunately, in the past, that has not been the case due to our outdated laws, which we inherited from the colonialists. Yeah? So, for example, our Criminal Procedure Code was enacted way back in 1962. You see, that is a very outdated law and really does not really cater for our current circumstances.